This is an archivist's tour of the New York Bill of Rights, which is Article 1 of our state constitution and has been since 1847. I'm going to focus on the right of petition, which is a very old right, and on due process, which has had a huge development in the modern era in our judiciary, both state and local and federal levels. If you've read the Constitution lately, Article 1(9) has language about the right to petition the government, and there's a fuller statement in the legislative law emphasizing that right. Petitions in our legal system actually have precedence in Dutch Roman law as it was practiced in New Netherland. Here's an example of a petition by various people in New Amsterdam to Petrus Stuyvesant and his council, demanding that revenue from the tax on beer and wine be assigned to the city treasury. You see signs right here in this document of the terrible damage in the Capitol fire of 1911. But really, our legal system derives directly, as we all know, from the English common law and equity law and other forms of law in England. And our founding fathers, our Constitution framers, both in the state and the federal governments, were very aware of these English precedents, one of the most important of which is the Petition of Right of 1628 to King Charles I. He assented to this petition because he was desperate for revenue, and he affirmed the Magna Carta, conceded Parliament's authority to levy taxes, and guaranteed the writ of habeas corpus. And so we have lots and lots of petitions to the royal governor of New York and his council after the English took over the Dutch colony in 1664. This is one of many, many examples from 1692, from the inhabitants of Schenectady, which had been burned by the French and Indians during one of several French and Indian wars in 1690. Their petition for relief of taxes was granted. In fact, the note by the clerk of the council is at the lower left of that document. Another petition from the colonial period, Hannah Travis, New York City, sentenced to death for homicide. This is her petition for mercy to the governor and council, and I'll read just a bit. Unto your honor and to the honorable council that your poor unhappy petitioner, not having the fear of God before her eyes as she ought ever to have had, has been seduced by the devil to commit a crime against God, the peace of our sovereign Lord the King, and his liege people, for which she stands condemned to an ignominious and shameful death. This is not Hannah talking. This is standard common law formulaic language in an appeal for mercy to the sovereign, and her petition was granted. Petitions, more petitions. During the French and Indian War, dozens and dozens of merchant shippers in New York City petitioned the governor for privateering commissions. Their boats, their vessels were stalled in the harbor. They couldn't go out and trade because of a trade embargo, because of the war with the French, and so they applied for licenses to seize French shipping, and this is just one of them, one of dozens. A famous name in early New York judicial history, of the state of New York that is, Robert R. Livingston, the first chancellor, applying for a land grant in what is now Vermont in 1771. Upon payment of large fees to the governor and other officials, the petition was granted. And actually, there were 35 petitioners because there was a limit on the amount of land that could be granted, 1,000 acres per person. Very likely, the other 34 were dummy partners who sold their share back to Robert once the transaction was completed. And here's actually one of the most significant petitions in the state archives, which barely escaped destruction. The petition of DeWitt and Clinton and many prominent citizens of New York City to build the Erie Canal, 1816. Petitions continue to the legislature throughout the 19th century. 1855, Ontario County, women and men many of them from the same families, Hathaway, Haight, petitioning for a constitutional amendment for women's suffrage. It took a long time. 1917, of course, that amendment was ratified. The right of petition continues today, but in modified form. Most petitions in the 17th, 18th, 19th centuries were in fact private claims for relief or local requests for special legislation, let's say. In the later 19th century, first statute, then constitutional provisions limited the right of petition somewhat, limiting private bills in the legislature, for instance. And we have a modern court of claims which handles claims against the state, though it has deep roots in the early Canal era. One can also petition the governor. Here is Governor Carey in 1980 with his council reviewing nice stacks of bills passed by the legislature. I'm sure it didn't look quite as calm and peaceful at midnight on the due date after 10-day bills. But the governor still, of course, as he has since the colonial period, receives applications for executive clemency, communications regarding bills, awaiting his signature or veto. Here's a couple examples of petitions to the governor. 1912, Carl Day, Clinton prison, dying of tuberculosis, petitioning Governor Dix for clemency. It was granted. These records are in the state archives. Another example from the 1930s. 1932, the Banking Board was established by legislative act, and there was major split in both parties about this legislation. Governor Franklin Roosevelt approved it, and there are hundreds of letters and telegrams for or against this important legislation. This is from the, what is it called? The League for Independent Political Action, basically a socialist organization looking for social control of industrial production and distribution, the chairman being John Dewey, the educator. And a much more recent bill jacket document, the Bottle Bill of 1982, petition from the Bronx saying, broken glass all over our streets does not exactly help the I Love New York campaign. And they were surely right. We've got 2,000 pages of for and against communications on this one bill. Due process. There it is in the Constitution. No person shall be deprived of life, liberty, or property without due process of law. There is obviously, as you all know, a parallel provision in the Federal Bill of Rights. I'm going to be concentrating on a few aspects of due process, illustrating often strange-looking, ancient-looking documents that embody continuing, persisting rights and procedures. They may look funny, but they were very important at the time, and they are still important today. Common law courts, indictment, trial by jury, habeas corpus, eminent domain. All right, you can't have remedies at common law or afforded by statute without tribunals, courts, to adjudicate, determine, and award damages, debts, relief of some kind. This is the very earliest first page of the minutes of the Supreme Courts from 1691. It has major damage. What's left of it was published in the 1950s in a magnificent edition from the New York Historical Society. But there were two courts up to 1847 that exercised common law jurisdiction: the colony and statewide Supreme Court and the county level courts of common pleas, in New York City also called the Mayor's Court. The Supreme Court continues today as our state's major tribunal. It was reactivated by the revolutionary government during the Revolutionary War. Common law actions and pleading were replaced by statutory civil actions and special proceedings and a much simplified pleading in 1848. And the Supreme Court has been reorganized, yes, several times in our history. Most recently, in a major way, in 1896, there have been added judicial districts, no additional judicial departments since then, but it still today exercises general original jurisdiction in law and equity, as well as important appellate jurisdiction. Trial by jury, indictment by grand jury. Here are the constitutional provisions. 1847 was the first time the Constitution permitted waiver of jury trial for civil matters. 1938 permitted waiver with some exceptions, capital cases, for criminal matters. Here is a writ of venere facias juratoris, Latin, lots of Latin. I had it in high school, and surprise, it's still useful. It's a sealed writ. It bears the seal of the Supreme Court of the State of New York. It's on parchment, as all writs or court orders, as the Supreme Court were, till the 1810s. Lots of sheep gave their lives for the judicial process, folks. And they were small because parchment was expensive. The writing was little. These are little documents, that big. Here is a panel of petty jurors for Circuit Court and the Court of Oyer and Terminer, Criminal Court in New York City, 1845. And of course, it's a tedious process to find and summon jurors. Some were issued written summons, some personal summons, simply orally. Some were not found. Others were disqualified because they were aliens or deaf, sick, or they were served as firemen, military officer, or whatever. Trial minutes from 1796. Gilbert Pell versus Alexander Thompson, an action for false imprisonment. This was the era of imprisonment for debt. This is still a civil matter. Imprisonment for debt was abolished when in New York State? Anybody know? 1830, pretty late. Attorney for the defendant was Robert Troup, a prominent Federalist lawyer. Assisting him was Mr. Hamilton. Guess who? But these minutes are typical of minutes then and now. It's a form that is stable and persistent throughout hundreds of years of our judicial history for jury trials. You have the names of the parties, their attorneys, the jurors, the witnesses, the sheriff, the constable, and the verdict for the defendant. But due process was not always as strictly as observed, especially in emergency situations. This is an example of an indictment based on depositions during the Revolutionary War against enemies of the state. They were, of course, otherwise known as loyalists, who were indicted and then convicted in the state Supreme Court sitting at Kingston, because New York City and Long Island and Staten Island were occupied by the enemy. Depositions against 45 defendants, suspected loyalists, just a few pages. All of the defendants resided in Albany County. All had been observed in uniform in Burgoyne's army marching toward Saratoga, or they had supplied that army. They lived in Albany, Scotticoke, Saratoga, and those places. They were indicted by a grand jury, the form and signatures at the bottom. A few months later, they were convicted in absentia, and their lands were forfeited to the state. They did not even have the right to appear or have counsel. This is contradictory to the very provision in the first state constitution that a defendant is entitled to counsel and to be present at his trial. This is a revolutionary situation. You can decide whether this is adequate due process. I think it's not. Habeas corpus. Here's an example of the flexibility of the common law. All these old writs, all these old forms, they were larded with legal fictions, imported en masse, verbatim from the common law of England, especially King's Bench and Common Pleas, these ancient royal courts in the mother country for most of these people in New York at the time. But habeas corpus was not only, and in fact was usually not, the writ used to inquire into illegal, possibly illegal detention, but it was simply a transfer mechanism. Now we have transfer jurisdiction. This was the way they transferred a defendant to, say, from common pleas to the Supreme Court. If for a matter of jurisdiction or attorney's preference, he could get the judge to order transfer of the case. And this is what this particular writ did. I do have slides to show you a real example of a writ of habeas corpus used to inquire into detention during the War of 1812. And it's a really interesting case because it may be the only case in New York's history of an indictment of defendants for the crime of treason under state law. As I said, during the War of 1812 and 1814, it is the case against three gentlemen, Aspinwall Cornwell, John Hegeman, Mark Lynch. They were brought by habeas corpus from the city court into the Supreme Court, by writ dated April 1814. And the writ doesn't say what the charge against them was. Well, attached to the writ of habeas corpus, the return by the officer of the lower court, is the commitment of Cornwell, Hegeman, and Lynch to prison in August 1814, charged with the crime of treason against the people of the state of New York by adhering to the enemies of the people. It sounds like the Bolsheviks almost, doesn't it, sort of? By furnishing the enemy with beef, pork, flour, and so on. They lived on Long Island. It seems as though British ships must have sent lighters or small boats ashore to buy supplies. It went to the Supreme Court. It was argued before the full court in the fall of 1814, and we were dismissed on the grounds that Britain was at war with the United States, not with New York State. And our Constitution even now says treason is a crime punishable in event of invasion or insurrection within the state. See? So it was an interesting case, reported 11 Johnson 549. The defendants were released and the war ended a few months later. I'm going to talk a little bit about the law of eminent domain, which is a kind of subset of due process of right of property, and here it is in the Constitution. Private property should not be taken for public use without just compensation. How just did New York State acquire lands and waters being an important resource, obviously, to run a canal, to build and operate the canal system? Laws of 1817, Chapter 262, empowered the canal commissioners, who had blanket power to do anything necessary to build those canals, to enter upon, take possession of, and use lands and waters necessary for the prosecution of the great improvement. The Canal Appraisers then made a just and equitable estimate and appraisal of the loss and damages, if any, over and above the benefit and advantage to the respective owners. So in other words, it's the exact reverse of what eminent domain now is. Now you have the taking occurs first, then the state or the local government moves in and builds the road, whatever it is. How then was this documented? And that's a question for archivists and historians, but it's also of legal interest. The law required those canal appraisers, the special officials designated to appraise damages and award compensation, that their determination and appraisal with sufficient description of the several premises appropriated should be recorded in books to be kept by the canal commissioners. Fee simple title vested in the people of the state. Where are those books? We can't find them. They would have been very important, obviously, comprehensive documentation of land ownership and takings for the Erie and Champlain and other canals. We think they may have been destroyed in the Capitol Fire of 1911. But there is a substitute. The revised statutes of 1829, a landmark in American legal history, the first real semi-codification of law in our country, required those canal commissioners to produce and certify a complete manuscript map and field notes of every canal. The maps, not the field notes, the maps, the graphical description of the state's right-of-way were to be presumptive evidence in all judicial proceedings. And here's an example of one of those maps showing the flight of 5 locks in Lockport, rebuilt, still operational today. The blue line indicates the state's right-of-way, the red line, the towpath. And that's the end of my formal presentation, but I will conclude with a non-commercial advertisement. Yes, as has been said, this is the 200th anniversary of the Erie Canal start of construction. Here's Lockport in 1839. Here's Lockport about 1890, the double flight of locks. Locks still operational today. This is an archivist's tour through some very odd and ancient-looking documents that illustrate the continuity and the durability of key provisions in our Bill of Rights. Thank you.
Great.